5 seconds to go. Start. Thus, while it can be said that this court has recognized some exceptions to the rule of alternative remedy, that is, where the statutory authority has not acted in accordance with the provisions of the enactment in question or in defiance of the fundamental principles of judicial procedure, or has resorted to invoke the provisions which are repealed, or when an order has been passed in total violation of the principles of natural justice, the proposition laid down in Thansing Nathmal case and other similar judgments that the High Court will not entertain a petition under Article 226 of the Constitution if an effective alternative remedy is available to the aggrieved person, or the statute under which the action complained of has been taken itself contains a mechanism for redressal of grievance still holds the field. Therefore, when a statutory forum is created by law for redressal of grievances, a writ petition should not be entertained ignoring the statutory dispensation. It could thus clearly be seen that the court has carved out certain exceptions when a petition under Article 226 of the Constitution could be entertained in spite of availability of an alternative remedy. Some of them are thus: where the statutory authority has not acted in accordance with the provisions of the enactment in question, it has acted in defiance of the fundamental principles of judicial procedure, it has resorted to invoke the provisions which are repealed, and when an order has been passed in total violation of the principles of natural justice. It has, however, been clarified that the High Court will not entertain a petition under Article 226 of the Constitution if an effective alternative remedy is available to the aggrieved person, or the statute under which the action complained of has been taken itself contains a mechanism for redressal of grievance. Undisputedly, the present case would not come under any of the exceptions as carved out by this court in the case of Chabil Das Agarwal Supra. We are therefore of the considered view that the High Court has grossly erred in entertaining and allowing the petition under Article 226 of the Constitution. While dismissing the writ petition, we will have to remind the High Courts of the following words of this court in the case of Satyavati Tandon Supra, since we have come across various matters wherein the High Courts have been entertaining petitions arising out of the DRT Act and the Surfacy Act in spite of availability of an effective alternative remedy. It is a matter of serious concern that despite repeated pronouncement of this court, the High Courts continue to ignore the availability of statutory remedies under the DRT Act and the Surfacy Act, and exercise jurisdiction under Article 226 for passing orders which have serious adverse impact on the right of banks and other financial institutions to recover their dues. We hope and trust that in future the High Courts will exercise their discretion in such matters with great caution, care, and circumspection. In the result, we pass the following order. The appeal is allowed. The impugned order dated 4th February 2022, passed by the High Court in writ petition number 5275 of 2021, is quashed and set aside, and writ petition number 5275 of 2021 is dismissed with costs quantified at Rs 1 lakh imposed upon the borrower, pending application, if any, shall stand disposed of. Stop.